We've now reached the module on record keeping. This is another very important module, and failure to comply could mean very hefty fines and prison sentences. Let's look at FICA sections and accountable institutions as regards to record keeping. Now, Section 22 of FICA creates a duty to keep and maintain records of all transactions when conducting business relationships. Section 23 states that records are to be kept for a period of at least 5 years. 5 years, guys. At least 5 years. Let's highlight least too, so that you remember it. Least 5 years, both for the establishment of a business relationship and of concluded transactions. Section 24 allows third parties to keep records on behalf of accountable institutions, but this means that they have to inform the FIC Center and they have to have free and easy access to those records. That means immediate access to the records. Section 25 states that all certified kept records are admissible as evidence in any court of law. And Section 47 states that failure to keep records by an accountable institution is an offence. What do we need to keep on record? Well, this important information includes the identity of the client, the identity of the person acting on behalf of the client and his or her authorization, the identity and authorization of the client where he or she is acting on behalf of someone else, the way in which the identity of the client was established, such as copy of the ID document, the nature of the business relationship or transaction. In the case of a transaction, the amount involved and all parties to that transaction, and all accounts involved, the name of the person or the employee who obtained the prescribed information, and any verification documents. Can you remember what the time frames were? Well, records must be kept of everything that was done with the client. These should be filed in a customer file and kept for a period of at least 5 years from the date when the business relationship was terminated or from when the single transaction was concluded. This means that all copies of documentation, including but not limited to letters, application forms, offers to purchase, quotes, receipts, emails, as well as further details mentioned are to be kept. If you have an established relationship with your client, you should confirm his details in writing at least once every year. Update records within 3 days of receiving a change of details and include proof that this has been done. And where may the records be kept? Well, the records may be kept electronically or by a third party, as long as the accountable institution has free access to it. Availability of records is most important. Any authorized representative of the Financial Intelligence Center is entitled to have access to any of the records during ordinary working hours if they produce a warrant issued by a judicial officer authorizing such access. The money laundering reporting officer has to immediately comply with such a request. So it is important that if you ask for any of the KYC CIV documents, that you provide them without delay. In addition, we must make sure that we understand we have to keep those records safe from destruction. It is our responsibility, and outsourcing this to a third party does not absolve the financial services provider from keeping those records. Finally, we also discovered that we had to keep our records for 5 years from termination of the product or of the service that we were given to that client. We also know what we have to keep, and we are aware of the fact that failure to do this is an offence, and we could then get a fine of 100 million rand or 15 years in prison. I hope that you'll see me on the other side of Module 6 for enhanced due diligence, when ordinary due diligence is simply not enough. There is also an assessment for this course. Please do it to see if you have understood the material so far.